This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor. This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
We're going to talk about the American system of evidence and its preference for an almost requirement for evidence in a case, in a criminal case, to come through witnesses, to come from witnesses who had firsthand knowledge about the facts of the case. In other words, a witness who was an eyewitness, or from a witness who was an ear witness, someone who may not have seen whatever it was, but had heard direct evidence about it. That's the preference. And really more than the preference, that is nearly the demand in American criminal courtrooms based on evidence law. In other words, the rules frown on evidence being admitted that is not direct evidence from a witness who observed the facts firsthand or who heard something about the facts firsthand. Now, today, we're talking about one of the largest exceptions to that rule, which is there are times in cases, frequently, in fact, where there are witnesses who have or may have helpful knowledge about the facts of a case, but who were not there. They were not eyewitnesses, or they were not ear witnesses. They don't have firsthand knowledge. And nonetheless, the rules of evidence allow these witnesses to testify. And we're talking about expert witnesses. But let me just give you two very, very quick examples. Take a homicide case, a murder, for instance, where the defendant in the case is being charged with a homicide, but there were no witnesses. And one of the main pieces of evidence, however, are fingerprints recovered from the scene of the murder. No eyewitnesses, no ear witnesses. In this little hypothetical, there must be a motive, which I won't get into, whatever that may be. But you would need a witness to testify about those fingerprints. That witness, again, not an eyewitness, not an ear witness, but instead it would be an expert witness who could help the jury understand what the fingerprints mean. Another example, not criminal, a car accident. where, again, no eyewitnesses other than the driver, no ear witnesses. The driver says that he was traveling the speed limit. The government says no, the driver was driving an excess rate of speed and was driving recklessly. The one piece of evidence that might be helpful is the length of the skid mark at the scene. The length of that skid mark might be able to tell you the rate of speed at which the driver was driving right before he had this accident. Again, no eyewitness is going to tell you that. No ear witness is going to tell you that. But an expert witness could come in and talk about the weight of the car, the condition of the roadway, and the length of the skid mark, and deduce from that, using physics and whatever else, how fast that car was traveling. There are really two leading cases that govern the admissibility of expert testimony in the United States. The first is the Fry standard. That happens to be an older case from the 1920s that has become, in almost every jurisdiction, outdated. But nonetheless, Chris and I are going to talk about it because it'll help explain the action of expert evidence so that we can understand it better. The Daubert standard is the more current standard. The rules of evidence in the United States have codified the rules of admissibility on expert witnesses, and that rule is Rule 702. Let's take that car crash hypothetical that I did. And let's say that there was an eyewitness to it. And that eyewitness says, I saw the car, it was traveling through the intersection, and it appeared to me to be going fast, faster than the speed limit. But what the eyewitness couldn't offer is an opinion based in his or her expertise about how fast that car may have been going. And that is one of the critical distinctions between what we call a lay witness and an expert. The expert could come in, based on my hypothetical about the skid marks, and could say, based on my expertise, I have an expert opinion about how fast that car was going. And in my opinion, that car was going 72 miles an hour, whatever it is. And that opinion is not something that lay witnesses, regular witnesses, the eyewitness that I mentioned, can offer. One of the first things we need to realize is that, as we have up here, expert witnesses are granted special status by courts. We are making a distinction between lay witnesses and eyewitnesses. And the distinction is made in the rules. And the rules acknowledge the difference. And expert witnesses just can't walk into the courtroom and start testifying. There's a series of requirements that need to be met before their testimony is admitted. One of the key distinctions is that the opinion, the evidence that the expert is presented to offer has to be beyond the ken of the average juror. That word ken is, it's an unusual-ish word, I think, in English. You don't hear it used very often. And it's a legal term of art now. And essentially what it means is that we prefer that fact finders, whether they're jurors or a judge, decide the issue on the evidence presented in court in addition to a juror or the group of jurors' own life experience. In other words, jurors can use their common sense. They can use logic to determine a fact at issue in a case. Things that are within their ken, within their experience, within their common sense. But there are many things, some very, very complicated, sometimes things not so complicated, which fall outside of a typical juror's experience, that they wouldn't have gained, life experience in determining. And those, generally speaking, are the areas that expert witnesses are allowed to come in and offer opinion testimony about. A couple of other distinctions, which I think we hope will guide our understanding about expert witnesses. Expert witnesses may consider a number of things in forming their opinions, and they can offer their opinion even if aspects of it are based on hearsay. In other words, expert witnesses, they're not eyewitnesses, they're not ear witnesses. Almost all of the information that they would have to offer their expert opinion is going to come from sources outside of their own experience. In other words, they are almost by definition basing their expert opinion on hearsay, what they've heard or seen from other people who have information about the case, including information in their own subject matter area, in their own area of expertise. One of the other distinctions about expert witnesses is that they can offer opinion testimony, something that lay witnesses cannot do. They can also be asked about and offer hypotheticals. So if a lay witness was testifying, a lay witness couldn't be asked, well, what if the car had been traveling 40 miles an hour? Would you have expected it to, skid that much or crash with that much force? You can't ask lay witnesses that question. Lay witnesses can't answer it. On the other hand, an expert witness in car crashes or an expert witness in fingerprint analysis could be asked those types of hypotheticals. And if the information falls within their area of expertise, they could offer an answer based in expert opinion. The last example is, and at least the way I conceive of this, is expert witnesses, not always, but frequently testify to industry standards. Go back to the second on the list here, beyond the ken of the average juror. Most jurors don't know what the industry standard is for car tires, or for safe rates of speed, or for fingerprint matching. I mean, how many ridges or points on a fingerprint collected at a crime scene have to be available in order to make a match? Lay jurors don't know that typically. And you can imagine, industry standards go on and on and on. They're in as many industries as there are. But experts in particular areas may have an expertise in a particular industry, and they can be brought in as expert witnesses to testify about whether the baby's crib exceeded or fell short of industry standards, in a case where the fact finder may be trying to decide whether the manufacturer was negligent or not. In a lot of criminal cases, which is sort of our focus here, I think it's fair to say, Chris may take issue with this, but I think it's fair to say that industry standards don't come up terribly much in criminal cases. It seems to me typically they come up more often in civil cases, because I think it's a good way to distinguish between lay jurors and experts. These are a list of things that are typically expert witnesses will testify about.
I would just add in terms of industry standards, because I was looking at where we're heading on this. And one of the kind of issues that is just beneath the surface of all of what we're talking about is the difference between scientific evidence and kind of other types of expert witness testimony. And so we're going to try to focus on the scientific aspect of this primarily, but we'll also talk a little bit about what expert witness testimony that is non-scientific, technical expertise is. So in terms of industry standards, if you're getting a non-scientist to talk about industry standards, it could be something like a police officer talking about drug packaging, right? Because he's an expert or she's an expert because they've encountered, drug packaging as a result of their police work for 20 years, right? And say that that's the way that cocaine is typically packaged, or that's paraphernalia for cocaine. I'm an expert in this area. So that's just another way that industry standards get in through expert witness testimony.